Good morning, ladies and gentlemen. The Judiciary Committee will now proceed with this hearing on enforcement of insider trading and the issue of hedge funds, where we now find enormous growth to more than $1 trillion a year, some 30% of the U.S. stock transactions. Sarbanes-Oxley had included in it provisions for criminal law enforcement, which came out of hearings from the Judiciary Committee, and this is the third in a series of hearings by the Judiciary Committee into this very important subject. We have circulated draft legislation, which will be the subject of comment here today, a concern about federal court decisions prohibiting coordination between the Securities and Exchange Commission and the Department of Justice, invalidating two criminal prosecutions. Question arises as to why that should be. What is the problem with having the SEC and the Department of Justice coordinate? We find that the whistleblower provisions of existing law have not been utilized by the Securities and Exchange Commission, and the draft legislation has a proposal to make awards at the discretion of the Attorney General in substantial amounts to whistleblowers who have proceeds going to the federal government by way of fine or settlement or other enforcement mechanisms. And with the development of the hedge funds, so that there are many who are now investing, who are the so-called smaller investors, the issue arises as to whether there ought to be regulation. That is really essentially a matter for the Banking Committee, and I have talked to Senator Shelby, the chairman, about that, and Judiciary Committee is making an inquiry, as is a Finance Committee led by Chairman Senator Grassley, who's also a member of this committee. And the draft legislation has a provision which would call for regulation where there are pension funds involved. Those are subjects which we're going to be considering in the course of today's hearing. The issue of the investigation into charges brought by Mr. Gary Aguirre has attracted the attention of the committee. There are a number of factors which raise issues. We have had the unusual result of Mr. Aguirre being involved in a very important SEC investigation and having favorable evaluations of his job and 2 pay raises, and then when he presses an investigation to have suddenly a reevaluation as to what he's been doing and to have him terminated. We have another investigator in the SEC expressing concerns about the nature of the investigation, what has been happening, and submits an email after being asked to be relieved of his responsibilities that there is something smelly going on. Then you have no action taken by the SEC until a Senate investigation is initiated. You have the deposition taken of Mr. Mack long after it might have been taken in the ordinary course of business, and curiously 5 days after the statute of limitations is run. You have the Inspector General of the SEC closing out an investigation without interviewing Mr. Aguirre. A little hard to understand that kind of investigative technique. What is the explanation? Well, that's something that this committee is going to try to find out. At best, it looks like extraordinarily lax enforcement by the Securities and Exchange Commission. That's at best. And at worst, it has the overtone of a possible cover-up. And those are difficult matters to ascertain. But we're dealing here with a very, very important subject. We're dealing with communications between individuals where there appears to be inside information on a pending merger, and some $11 million is gained by transactions related to that. And the matter is referred to the SEC, and nothing is done for 2 years. And finally, when the investigation by Mr. Aguirre is picked up, those events occur. Well, maybe it's just smoke, and maybe there is no fire. But where you have hedge funds with as dominant a role as they're playing in the economy, more than $1 trillion, and their expansive nature in picking up smaller investors and pension funds, this committee is charged with oversight on enforcement. These are very, very important matters. In reviewing the orderly sequence for today's hearing, I had wanted the witnesses who are at the table now as to panel one, but I believe it would be more efficient to alter the presentation. So we're going to hear first from Associate Deputy Attorney General Ronald Tenpass and Connecticut Attorney General Richard Blumenthal. So if you gentlemen would sit back, and Mr. Tenpass and General Blumenthal will step forward, and Ms. Linda Thompson will be in the second panel. Yeah, resume. Our first witness this morning will be the Connecticut Attorney General Richard Blumenthal, an outstanding record in public service, having served in the Connecticut State Senate, State House of Representatives, and as a U.S. Attorney for the District of Connecticut, was law clerk to Justice Harry Blackmun, formerly assistant to Senator Abraham Ribicoff, and presidential assistant Daniel Patrick Moynihan before he became a senator, a Phi Beta Kappa graduate of Harvard and law school from Yale, and editor of the Yale Law Journal. Pretty good pedigree, Mr. Blumenthal. We welcome you here and look forward to your testimony.
Thank you very much, Mr. Chairman. I appreciate this opportunity to be with you again, and I want to thank you as chairman of this committee, as well as the committee itself, for its leadership in this absolutely critical area, focusing not only on the specific instance that you've just outlined so well of potential problematic laxity in investigation, but also on the more general problems that arise with respect to hedge funds. And with your permission, I'd like to present a much abbreviated version of my testimony and then have the full text entered in the record.
Attorney General Blumenthal, your full statement will be made a part of the record, as will all other statements, and we appreciate your summarizing.
Thank you. As you've very correctly observed, hedge funds have become more and more retailed in the financial markets to investors who are no longer the wealthy and sophisticated individuals who once were viewed as the sole kinds of investors, and now the $1 trillion and 9,000 hedge funds that are involved in this industry span a much broader section of the American public. But equally important, they involve investment vehicles and instruments such as credit default swaps and increasing use of public offerings, bonds, and so forth that can impact the markets, the investments in commodities, as we saw with Amaranth, can have a huge sweeping effect on those markets, and potentially for good but also for ill. And so I think that the emphasis in the draft discussion bill on greater disclosure of risk strategy and of other very relevant factors in operation of hedge funds is absolutely going in the right direction. I want to emphasize also the importance of protecting whistleblowers, and I think that point is directly relevant to the specific subject relating to Pequot that brings us here today or has elicited the committee's attention. The kinds of rewards for whistleblowers we have found in our investigation, protection for people who are willing to risk their lives and livelihoods, their careers and reputation, is critical. And the idea of providing, for example, 30% of any sorts of civil fines and penalties as a maximum, 30%, as much as 30%, is a very, very promising concept, and I think, in my view, based on my experience in our investigation, is a very worthwhile avenue to pursue. I want to also emphasize the importance of concurrent jurisdiction. It's mentioned in my testimony, but I think, again, it is an area that acquires even greater importance in light of the potential problems in the Pequot capital investigation by the SEC. Concurrent jurisdiction that enables states to be active participants and partners, but also empowered to conduct their own investigations in this area if necessary, has been one of the lessons, I think, in recent history, whether in securities, insurance, environment, the role of states in active, aggressive law enforcement, where the federal government either purposely or inadvertently abandons the field or fails to be sufficiently aggressive, is a lesson that I think is applicable here as well. The kinds of experiences we've had in Connecticut with hedge funds, whether Amaranth or Bayou, others obviously across the country where there have been failures, I think emphasize the importance of that concurrent jurisdiction where states like Connecticut, which have a very heavy representation of hedge funds, can be an active participant, is very important in my view. And finally, I want to just emphasize one very important feature of changing the law that I think should be examined by the committee: raising the net worth or income levels that are required for participation in hedge funds is one of the most important steps that this committee could take, or that the SEC could take, because it will raise the bar, so to speak, and enable investors themselves to be of the type that can do their due diligence, that will have the assets and the sophistication that hedge funds initially were supposed to provide, and that hedge fund investors were supposed to have. And so I would suggest, for example, that the net worth requirements be raised to $2 million. Presently they're $1 million or higher, and that the minimum requirements for income in investors be raised far higher than the $200,000 now, as an alternative to that $2 million, perhaps on the order of $500,000. These numbers are illustrative, as I indicate in my testimony, but again, such requirements would help ensure that hedge fund investors are capable of doing that due diligence and assessing the risks that informed hedge fund participation requires. I want to thank the committee for giving me this opportunity, and look forward to continuing my contribution as someone who comes from a state where hedge funds are a big part of our economy. We want there to be federal action rather than a patchwork of different state rules or guidelines. We want the federal government to take the lead, because we want to avoid disadvantaging hedge funds in any single state, and instead we should have uniform national rules, stronger protections for investors in disclosure and accountability than we do now. Thank you.
Well, thank you, Attorney General Blumenthal. We appreciate your coming back to testify and appreciate what you're doing on the state level, and we thank you for being with us. We're joined now by Senator Grassley, who, as I had mentioned earlier, has taken the lead with the Finance Committee on inquiries into what's happening with hedge funds, and he is chairing another hearing. So since he's a distinguished member of the class of 1980, one of the two remaining members of that class, I'm going to yield to him at this time.
Okay, thank you. I appreciate your courtesies. I also appreciate your continued cooperation that you've given with my committee in working on this issue. And I also ought to appreciate the cooperation of the Security and Exchange Commission, and particularly Chairman Cox, in providing documents, information, and witnesses to both the Finance and Judiciary Committees during this investigation. The SEC is recognizing the constitutional responsibility of Congress to conduct oversight of federal agencies. A lot of other federal agencies, especially Health and Human Services and the Justice Department, could learn a lot from this good example set by the SEC. Now, today's hearing is the second by this committee relating to penalties for criminal enforcement of illegal insider trading, and the third that has discussed the evolving role involving hedge funds. And so I want everybody to know that I share Chairman Specter's concerns about the extent of insider trading and its impact on public confidence in the fairness and integrity of the stock market. This committee has jurisdiction over criminal laws, and with today's hearing, we need to see if the laws on the books are strong enough to see that they are enforced in a way that Congress intended. We're also here today to discuss allegations brought by the former SEC attorney Gary Aguirre. His allegations led to a joint Finance Judiciary Committee investigation on whether there was retaliation against this SEC lawyer for his role in the investigation of a large hedge fund. The Senate investigation also focused on the original investigation of these allegations by the Inspector General of SEC. Today we'll hear about findings from the Senate's committee's investigation, along with information learned through witness interviews and an extensive review of SEC documents. We'll dig into why the Inspector General failed to uncover important evidence corroborating many of these allegations. We'll also question Mr. Gary's supervisors about the debate that went on inside the SEC about whether and when to ask a high-profile Wall Street executive some key questions during its insider trading investigation. The resistance of the SEC to taking Mr. Mack's testimony until after the press and Congress put a spotlight on issues raised serious questions for me about whether captains of industry get the same treatment as regular investors or whether they get treated with kids' gloves. Finally, we'll question Mr. Gary's supervisors about the SEC's personnel process and why they created an alternative negative evaluation of Mr. Gary that wasn't submitted into his personal file until after they fired him. I'd like to hear how they can square that with his original positive evaluation and the pay increases that he got. It looks like that negative evaluation was only created after Mr. Gary started complaining to his supervisors that it was unfair to treat John Mack differently than the SEC would treat an average investor in the same situation. That's not a legitimate reason to go back and change an employee's performance evaluation. These issues point to problems within the agency that distract from the core mission of protecting investors. This hearing can kickstart some necessary changes at the SEC. This hearing is about finding solutions as well as exposing problems. And I thank you, Mr. Chairman, and I'll be back to ask questions.
Thank you very much, Senator Grassley. Thank you for your leadership and extensive work on this important subject.
Thank you.
We now turn to Associate Deputy Attorney General Ronald Tempest, who has responsibilities including coordinating work by the President's Corporate Fraud Task Force and reviewing policy proposals relating to preventing and punishing crimes in the corporate world. Previously, Mr. Tempest was U.S. Attorney for the Southern District of Illinois and an Assistant U.S. Attorney in both the Middle District of Florida and the District of Maryland. Clerked for Chief Justice Rehnquist and Judge Pollack of the Eastern District of Pennsylvania, bachelor's degree from Michigan, law degree from the University of Virginia, and a Rhodes Scholar. Thank you for being with us today, Mr. Tempest, and the floor is yours.
Thank you. Thank you, Senator Specter. Thank you for the opportunity to be back and talk again about this issue. I thought in my openings I would focus my remarks on the bill's criminal provisions, the draft bill that you've shared with us, and try to highlight the effect some of those provisions would have on our criminal enforcement efforts. As we've discussed in my prior appearance here, there's a division of labor in this arena between the civil and criminal enforcement efforts, with DOJ having the lead in the criminal enforcement arena. Let me start my discussion with Section 4 of the bill. This section would amend Title 18, Section 1348, by adding a new subsection B that would expressly prohibit insider trading. We believe it could be helpful to put insider trading offenses on a firmer statutory footing than they now stand, which is really as a species of judicially recognized Title 15 offenses, where Title 15 prohibits schemes to deceive associated with the offering and sale of securities. Creating some statutory clarity here on that court-created in that court-created arena could be helpful to us. We do have a number of concerns about the specifics reflected in the bill. For example, the section is entitled Willful Misuse of Material Non-Public Information, yet the new paragraph B21A incorporates a knowingly standard, while paragraph B21B provides no explicit scienter requirement. The new subsection B, as currently worded, introduces at least two substantial changes from current law. It eliminates the element that a person who is charged with insider trading be shown to have a duty with respect to that information. And we have concerns that eliminating this requirement potentially subjects to criminal sanctions those who might innocently come by valuable information and trade on it. Conversely, the draft bill essentially adds a new affirmative defense that trading on insider information is acceptable if that information was gained by, quote, research and skill. Such a formulation will make it more difficult to prove insider trading than is the case under current law, where no such defense exists. Similarly, some of the phrases such as of a specific nature, significant, and the phrase significant factor, which are included in the legislation, would impose burdens that we do not currently face, and so give us concern. We think perhaps a better model may be to look to the definition of insider trading that the SEC has already promulgated through its regulatory process, and then build from that if any adjustments are necessary. Obviously, we would be happy to work with you and other members of the committee on such an effort going forward. Similarly, in Section 4, paragraph C, we welcome the effort to make clear the Department's authority to investigate insider trading offenses and to do so in a manner that involves express coordination with our partners at the SEC. As you noted, there have been a couple of court decisions in this arena recently, and the United States has appealed one of those decisions that has unfortunately created potential barriers to the conduct of parallel investigations. Thus, while we welcome the the thrust of the effort to cure some of this, we would urge that any final decisions on how to respond be made after the appellate court releases its decision, so that we can ensure that any legislation provides as comprehensive a fix as possible in light of where the law will stand at the time of that decision. Even as that section is framed right now, there are things that we'd hope to have a chance to work with you and the committee on to perhaps tweak a bit. Proposed paragraph C2 of Section 1348 would provide that neither the Attorney General nor any other federal agency would have a duty to disclose any investigation or to disclose any contacts made with a companion agency to request or receive evidence, is the language in the bill. But we have traditionally coordinated our efforts with the SEC through more than just requesting or receiving evidence. Thus, this language might be argued to cut back on rather than to confirm the propriety of some of these traditional coordination efforts. And similarly, the language in the proposed bill applies only to investigations of violations of this section, i.e. Section 1348 of Title 18. Yet we continue to have parallel proceedings that involve other criminal provisions of Title 18 and Title 15, which could be equally frustrated or affected by these court decisions. And so, again, we would be concerned about some of the particular language contained in the bill. Let me also briefly turn to Section 5, the section to create incentives for private citizens to report and assist in the investigation of insider trading. We always welcome the assistance of private citizens who report criminal acts. However, giving such substantial financial incentives to individuals to make criminal allegations would be a fairly dramatic departure from past practice in the criminal arena, and will introduce new complexity for us and thus raises concerns. Such financial incentives may produce not only meritorious allegations that are helpful, but also false allegations that can result in individuals being falsely accused. It will be important grist for impeachment of key government witnesses, and we are concerned about whether the factors the statute indicates should be considered in fashioning a reward amount are meant to be exhaustive or only illustrative. For example, we think it would be significant to consider whether the person who provides the information was himself complicit in the crime, and that's not a factor that's identified as a factor for consideration. Let me conclude there. I have laid out in more detail in the written testimony other examples of specifics that we observe we'd like the opportunity to work with the committee on further. Thank you.
Thank you very much, Mr. Tenpass. I will include in the record at this point a statement from Mr. John P. Wood, Chief Executive Officer and Chairman of the Board of the TELUS Corporation, a 4-page analysis favoring the draft legislation. Mr. Tenpass, the jurisdiction of the Judiciary Committee led to the enactment of 18 United States Code 1348, Criminal Code, in 2002. And the question I have for you at the outset is how many indictments have been brought under that statute?
We've brought just over 50. I think the number is around 53, 54, something in that
and
neighborhood.
How many of those involve insider trading?
We don't have a good way to measure that.
Why not?
Senator, because as I alluded to earlier, insider trading is a species of schemes to defraud, and so we simply, in our statistical programs that track this, we track the statute that's been charged. We don't necessarily track sort of the underlying theory that's been used. Is it insider trading? Was it accounting fraud? Or any of the other kinds of things that might be a violation of the statute?
Tenpass, insider trading is sufficiently important so that I think it would be very useful to this committee if you would make that identification, because that's a little different species. So would you endeavor to do so?
We will do so.
Mr. Tenpass, just last Thursday on November 30th, Mr. Michael Tom of Global Time Capital Growth Hedge Fund was given 3 years probation in Boston involving a trading tip that Citizens Bank would be acquiring Charter One Financial. He made a $750,000 profit on that transaction and got 3 months probation. Is that sentence adequate?
I'm not
an assistant U.S. attorney in 2 districts, U.S. attorney in 1 district. The assistant prosecutors have a pretty good feel for that. I recall my days as an assistant DA, 3 months probation for $750,000. That's more than you get paid, $250,000 a month. What do you think?
I'm simply not familiar with the specifics. We'd be happy to go back and look at it and advise the committee of what went into fashioning that sentence. Obviously, as you're aware, the sentence ultimately is determined by the court, and I'm not certain whether the United States made a particular recommendation in that case or not.
Well, is there any coordination on DOJ recommendations? The Department of Justice does make recommendations. We do know that it's up to the judge.
We certainly, the United States Attorney's Office will, the prosecutor assigned to the case will typically make some, give some indication at the sentencing of the appropriate sentence.
That's a pretty big case. I would have thought that you would have had some familiarity with that. You're in the key position. Aren't those matters brought to your attention for your input?
A case of that magnitude would not necessarily or routinely.
What magnitude would it take?
It's usually going to be in bigger than that, in the several millions of dollars. Our U.S. Attorney's offices routinely handle matters in which the loss or the fraud is in the hundreds of thousands of dollars, and so a case of that magnitude, given what you've described, is not something that I would routinely expect to come to officials in Washington.
Mr. Tenpass, let me suggest to you that $750,000 is significant and that it's a very bad sign to get 3 months probation on that kind of a case. Attorney General Blumenthal, there has been the overall approach that voluntary procedures within the industry would be sufficient. And after the long-term capital management collapse 8 years ago, voluntary industry changes were implemented to control potential abuses in hedge funds. And then, as you noted in your testimony, Amaranth came along recently, some $9 billion in losses. How do you evaluate the overall approach that the industry can regulate itself, that the banks' involvement puts them sufficiently at risk so that they will make independent inquiries, and that it is not necessary to have governmental regulation?
I think that there is a growing consensus within the hedge fund industry that measures to require greater transparency are inevitable and necessary. The voluntary self-policing, I think, continues to put at risk lenders to the hedge funds, commodity markets, as well as individual investors that now include pension funds, university endowments, a much broader cross-section of the investing public.
When you mention voluntary procedures, just what does that involve?
Essentially, it involves primarily the investor doing the due diligence and getting from the hedge fund information that is thought necessary about investment strategies, types of investments, degrees of return, past performance, baseline performance, compensation for hedge fund managers, all of the key areas that are identified in your proposed draft bill. And I think that is one of the very central points about this draft bill, that it identifies that information through A, B, C, D, E, the investment objectives and strategies, the risks, the side agreements, the extent of audits. I think those are the key pieces of information that right now voluntarily, to answer your question directly, are provided supposedly by the hedge funds. The problem is that a lot of the investors, even some of the largest pension funds and endowments and others that should have that analytical ability, simply either lack it or are not provided with complete information. And right now there really are not the kind of oversight and scrutiny that this bill envisions for that truth-telling process, that disclosure issue.
Did Amaranth involve pension funds?
There were pension funds that lost money in Amaranth. Indeed, I believe one in California lost about $87 million, the pension funds of one of the cities in California. And as you know also, Amaranth involved use of the electronic trading issues through the Intercontinental Exchange that right now is not subject to the kind of disclosure requirements that NYMEX is. So that's another area where hedge funds are involved in practices where more disclosure should be required. But
were small investors involved in Amaranth as well?
I know some of them personally. Amaranth was and continues to be a Connecticut hedge fund. I think it's now non-operational, but many smaller investors in my own community, in Greenwich, Stamford, Connecticut generally, were involved in Amaranth, as they were involved in Bayou.
Do you have any idea how much they lost?
Well, the total losses probably were in the range of $6 billion out of the $9 billion that Amaranth had, because $6 billion was approximately the amount that was invested in natural gas futures. But some of these were losses of life savings, and some on the part of people who couldn't afford to lose them.
And when you talk about small investors, how do you define small?
Well, small investor would, in my view, be anyone who can't afford to lose the amount invested. And in different communities, it may be different amounts. Right now, the $1 million net worth threshold for accredited investor in parts of Connecticut, New York, New Jersey, Pennsylvania, many areas of our country, is still a small investor, but many of the investors that I have in mind had net worths well below that $1 million.
Mr. Tenpass, what is your evaluation of the adequacy of these so-called voluntary industry practices to safeguard against inappropriate practices by hedge funds?
I think that's a little beyond the department's ken. The President's Working Group on Financial Markets that's chaired by the Treasury Department includes the SEC, the Federal Reserve, and the CFTC is really the group that is looking at that, understands those markets and the way they work better than we do. And so I think I'd have to defer to that group of folks to give you a sensible evaluation.
Let's come back squarely within your so-called can on the parallel investigations by the SEC and the Department of Justice. You do favor a change in the law or a specification of the law to deal with the federal court decisions which have stricken prosecutions on that, on the ground that it was inappropriate to have a parallel or coordination between the SEC and the Department of Justice.
Well, we'd welcome, I think, some clarification. We think those cases were wrongly decided, so I'd be reluctant to say that we think a change in the law is needed. There have been a couple of cases decided since the Stringer case that have rejected some of the language in Stringer and the Scrushy case, but so I'm not sure we need a change, but we need some clarification that the view we have taken is in fact a correct view of
clarification that you can have parallel investigations with appropriately.
Yes, I think clarification that the department and the SEC or other similar regulatory agencies can communicate with each other about and coordinate their investigations for appropriate purposes.
When you mentioned that we ought to await the decision by an appellate court, what is the status there? How long do we have to wait?
It's still being briefed. Oral argument has not been held, so it would probably be at best sometime this spring, early summer. It's in the Ninth Circuit, so it's a little hard for us to predict how long they'd have it under advisement.
So you think it might happen sometime next year?
I think so.
Congress has a pretty good record at waiting, even without a specific reason, but I think this is something we really ought to be acting on. Attorney General Blumenthal, you talk about protecting whistleblowers. I agree with you. It's not easy to come forward and make an identification, but it's indispensable to have real law enforcement. Prosecutor, Mr. Tenpass was, so we know from our common experience how hard it is to gather this information, which is done behind closed doors and in secrecy. Do you think the current protections for whistleblowers, those protections are adequate?
Overall, I think not, Mr. Chairman. I think there needs to be a stronger shield, protection against retaliation, indirect as well as overt and direct forms of revenge or retaliation. Often, as you know, they can be subtle, pernicious, but long-lasting on a person's career. We see it at the state level, obviously, which is the arena where I practice now. Just yesterday, as a matter of fact, my office produced a report that culminated a 13-month investigation of the Internal Affairs Unit of our state police that resulted from state troopers themselves having the courage and conviction to come forward with complaints about a system that was in disarray. And we have protected those whistleblowers. We're able to do so as best we can at the state level, but we need the kind of rewards, I think, and incentives that your draft bill proposes, as well as the shield. We need the kind of incentives that will provide a financial security, maybe the best way to characterize it, for people who come forward and take the risk that government may not be able to protect them. We saw it in the tobacco cases, where we were guided initially by whistleblowers, now well known, but arguably the states would not have had the evidence and the guidance that we needed there without whistleblowers from the tobacco industry. Again and again, what we see is not just disclosure of information, but also providing a roadmap. As you know from your prosecutorial days, and I'm sure Mr. Tenpass does as well, one of the classic tactics of potential defendants is to deluge prosecutors with documents. Having a roadmap, having someone to guide that effort, to pinpoint the documents that are critical, often is invaluable. And again, whistleblowers provide that service. So I apologize for the long-winded answer, but I believe that a greater measure of protection, as you have sought, as the committee is seeking to do in this bill, is absolutely vital.
That's not long-winded at all, Mr. Blumenthal, by Senate standards. Well, thank you very much, Mr. Tenpass and Attorney General Blumenthal. We very much appreciate your testimony. Mr. Tenpass, if you would follow up on those outstanding issues, and Attorney General Blumenthal, keep going.
Thank you very much,
Thank you very
Mr.
much.
Chairman.
At this point, I will put on the record a lengthy analysis of 6 pages by Mr. Mark Kasowitz of the AI Alliance for Investment Transparency, dated September 4th, 2006, in support of the draft legislation. Will all of you please stand for the administration of the oath? Raise your right hands. Do each of you solemnly swear that the testimony you will give before this committee will be the truth, the whole truth, and nothing but the truth, subject to the laws on perjury? I do. May the record show that each of the witnesses has said I do. Mr. Aguirre, thank you for returning to testify before this committee. Mr. Gary Aguirre is a former senior counsel with the Division of Enforcement and the Securities and Exchange Commission, has nearly 40 years of litigation experience, including the areas of construction disputes, environmental regulation, securities litigation, and criminal defense. Published many scholarly legal articles, including one arising from litigation from the Enron debacle and the application of Section 10B of the Securities Act to fraud. Bachelor's degree in politics and law degree from the University of California at Berkeley. A Master of Fine Arts from UCLA and a Master of Laws from Georgetown University Law Center. Thank you for being with us, Mr. Aguirre, and we look forward to your testimony again.
Thank you, Senator Specter. I'd like to express my gratitude for the time that your staff has taken to look into this matter and your leadership in looking into this matter. Before I touch on the Pequot case, I'd like to speak briefly about the SEC's track record on the subject you're looking at. The SEC has brought, and I'm talking, of course, about insider trading investigations of hedge funds, and specifically those that result.
Mr. Aguirre, is your microphone on?
Testing. I'll move a little closer. Specifically about SEC cases that have been filed against hedge funds for insider trading. It's a short record. There are 6 cases. 3 of those cases are PIPEs cases. PIPE transactions are a filament, a tiny, tiny, thin aspect of our capital markets. Last year they were $20 billion. Compare that, for example, with our merger and acquisitions market, which is $1.46 trillion. Half the focus was on this. On all the other types of insider trading, whatever it is, mergers, acquisitions, tips before earnings, tips before drugs, everything else, there are 3 cases. The total recovery in those 3 cases is $110,000. That is the track record of the SEC in pursuing insider trading, with the exception of the PIPEs cases. And in the PIPEs cases, they recovered $25 million. Now, those 3 cases deserve a little more comment. 2 of them involved tiny, tiny hedge funds. And the third took them 5 years to file a case. Now, I'd like to talk for a moment about the Pequot case, and in particular on the date of June 14th. On that date, I was meeting with Mr. Hansen and Mr. Kreitman. I was reviewing for them the status of the case of that moment. I had reviewed the status of the evidence involving Mr. Pequot itself, Mr. Sandberg, and as well as Mr. Mack. That day, they authorized me to meet the next day with the FBI and the U.S. Attorney and present the same facts to initiate a criminal investigation. Now, that's a serious matter. That's why I was so shocked when 9 days later, they would not permit the issuance of an administrative subpoena for Mr. Mack's testimony. Of course, something had changed during those 9 days. On June 23rd, the Wall Street Journal announced that Mr. Mack would be a candidate as the CEO for Morgan Stanley. On June 22nd or June 23rd, Mr. Hansen explained to me that I could not issue that subpoena for Mr. Mack for one reason, and he gave me only one reason, and that reason was his powerful political contacts.
Mr. Hansen told you that?
Face to face, on twice that week. Now, that event was followed very quickly by a phone call from Morgan Stanley, in which I was told by Morgan Stanley's compliance officer, we got a problem with Mr. Mack if you guys are going to go after him. That investigation vanished in a week, and in that same 7 days, Mr. Mack went from a candidate for CEO to CEO. The rest of my time, I continued mining the evidence against Mr. Mack. I continued presenting that evidence, and every time I presented it, the bar went up another notch, and the bar went up another notch. And finally, it was a 9-foot bar. I'd like to say just a few words about my evaluations. They were touched on by Senator Grassley, the remarkable way I had a reevaluation out of nowhere. I read this morning the testimony that has come in from the SEC and the attacks. I have not seen a single piece of paper backing anything that they have said throughout my history with the SEC, and I've been trying to get them through FOIA and Privacy Acts. Thank you. I think my time's run out.
Thank you, Mr. Aguirre. Mr. Hansen, I'm going to go to you out of order so that you'll have a prompt opportunity to respond to Mr. Aguirre's statement that he and you face-to-face had an exchange where, according to Mr. Aguirre's testimony, you told him not to proceed with an administrative subpoena as to Mr. Mack because, as Mr. Aguirre puts it, his powerful political contacts. The floor is yours, Mr. Hansen.
Thank you, Inspector. I did not say that to Mr. Aguirre. I did not say that to Mr. Aguirre, as he states. I have no recollection of making that statement. In fact, I had no knowledge at all about Mr. Mack's political connections at that point. I certainly knew that Mr. Mack was a very high-profile individual, but I had no idea until I read in the New York Times recently about Mr. Mack's political connections. I didn't even know what a ranger was until I read that in the New York Times and looked it up. So I had no idea what that was at the time Mr. Aguirre alleges that I told him that.
You may proceed with your testimony generally, Mr. Hansen, as you choose.
Thank you, Senator Specter. Thank you for the opportunity to testify today and to respond to false allegations of abuse of authority that have been advanced by a former staff attorney of the United States Securities and Exchange Commission. I appreciate the opportunity to set the record straight on the matter about which Mr. Aguirre testified to this committee last summer. I have spent my entire legal career in federal government service. currently a branch chief at the SEC, where I've worked for approximately 8.5 years. Every day I get the chance to work with motivated professionals dedicated to the agency's mission. It is a great honor and privilege to do so. Let me state that in my experience, the Division of Enforcement of the SEC has never considered an individual's political connections in deciding whether to take his or her testimony. No one has ever asked or suggested that I refrain from taking a person's testimony because of his or her political connections. In conducting and supervising investigations, I follow the evidence wherever it leads, even if the trail points to a prominent executive or a public figure. In the investigation concerning the hedge fund Pequot Capital, I have no reason whatsoever to believe any outside source ever attempted to influence the decision on taking the testimony of anyone. I supervised Mr. Aguirre before he was terminated. I found him to be highly energetic, but his conduct was erratic and unprofessional. It was extremely difficult to communicate with Mr. Aguirre, and miscommunications were common. Information that Mr. Aguirre presented as fact often turned out to be mere speculation, and he admitted information that did not support his hypothesis. He did the same thing in his written testimony he provided today, failing to bring to the committee's attention the inconvenient fact that CS First Boston Counsel had told Mr. Aguirre that the individual who Mr. Mack met with before Mr. Mack joined CS First Boston did not even have the information that Mr. Aguirre had relied on to support his theory that Mr. Mack had received the information from CS First Boston before joining the firm. One by one, Mr. Aguirre alienated the other staff attorneys and the assigned trial attorney on the case, treating them with open hostility for no valid reason. At least twice, Mr. Aguirre angrily stormed out of the office during the workday after disagreements with other attorneys in the spring of 2005. Both times he said he was going to think about what he was going to do, which I understood him to mean that he was planning to leave the commission. He formally tendered his resignation in June 2005, but later withdrew that resignation. I learned that he had withdrawn his resignation through the grapevine rather than from him directly, even though I was responsible for staffing the case. Mr. Aguirre then said he would be willing to work to complete the investigation, but would not document his findings, which was essential to completing the investigation. It became apparent that Mr. Aguirre was a significant risk to leave at a moment's notice, regardless of the impact such action would have on the investigation. His erratic behavior and the negative impact it had on the other attorneys on the case and on the investigation compelled me to strongly urge that Mr. Aguirre be terminated before his probationary period ended. I was not the first supervisor to recommend that Mr. Aguirre be terminated. Mr. Aguirre's public assertion that the Pequot investigation was halted is utterly false. After he was terminated, the Division of Enforcement continued the investigation unabated, devoting hundreds of hours to the matter. After Mr. Aguirre's termination, investigative staff took testimony from or interviewed more than a dozen individuals, made numerous formal and informal document requests, reviewed and analyzed thousands of documents, and participated in 2 proffer sessions with the FBI and the Office of the U.S. Attorney for the Southern District of New York. No shrinking violets. Ultimately, after a thorough investigation, we closed the matter after finding insufficient evidence to warrant bringing an enforcement action. While at the SEC, every investigation I have worked on has been conducted with fairness, diligence, and integrity. We did so in the Pequot investigation. Thank you. I would be glad to answer any questions you may have.
Thank you, Mr. Hanson. I want to make it a part of the record as to your background. You are the branch director in the SEC's Division of Enforcement, and you were Mr. Aguirre's immediate supervisor at the time of his termination. Prior to joining enforcement, you were a staff attorney with the SEC's Office of Compliance, and previously had served with IRS in the Office of Chief Counsel, a graduate of the University of Delaware and the University of Maryland School of Law. Mr. Hanson, let me bring up at this point, as a matter of sequence, a couple of memoranda, one from you to Mr. Aguirre dated August 4th, or an email, which you have involved with other comments. This statement, quote, Max counsel will have, quote, juice, close quote, as I described it last night. meaning that they may reach out to Paul and Linda and possibly others. Do you recollect writing that statement?
I do.
What did you mean by juice?
Well, as I explained in my written testimony, although I had no reason to know who would represent Mr. Mack if he was called to testify, I knew he would retain experienced SEC counsel who would likely, as is not uncommon, directly contact my superiors about the testimony.
A second written communication was from you to Mr. Kreitman, dated August 24th. And the second paragraph says, quote, "Most importantly, the political cloud I mentioned to you was a reason to keep Paul and possibly Linda in the loop of the testimony. As far as I know, politics are never involved in determining whether to take someone's testimony. I've not seen it done at the agency. It does make sense, though, to have all your ducks in a row before approaching a significant witness like Mack, hence the reason to try to figure out a number of things about him before scheduling him up, not the least of which is whether he knew about the deal. Was there some special precaution or preparation you took as to Mr. Mack within the context that, as I've quoted here your statement, that politics are never involved in determining whether to take someone's testimony? Was there any special precaution taken as to Mr. Mack?
The precaution I did want to take was I wanted to see what information we could learn about Mr. Mack before trying to take his testimony. And as I do mention in that email, politics have never been involved in deciding whether to take someone's testimony.
We're going to go now to Ms. Linda Thompson, who is the Director of Securities and Exchange Commission's Division of Enforcement. Joined the Securities and Exchange Commission in 1995. Prior to that, served as Assistant U.S. Attorney for the District of Maryland, bachelor's degree from Smith and a law degree from Harvard University. I'm going to take you out of sequence, Ms. Thompson, at this time, because I think that there ought to be as early an opportunity as possible to respond to Mr. Aguirre, and then we'll have further questioning, but you may proceed at this time.
Thank you, Senator. Chairman Spector, thank you for inviting me to testify today. I have submitted written testimony and asked that it be made part of the record.
Your statement will be made a part of the record.
Thank you, Mr. Chairman. I'd like to start briefly on some of the broader issues that you raised in the first panel. And as that earlier panel discussed, and indeed as Mr. Tenpass and I discussed with the committee earlier this fall, the pursuit of illegal insider trading is an important and challenging part of the overall enforcement of the federal securities laws. The same is true for illegal activity by hedge funds, important and challenging. We at the SEC are committed to pursuing enforcement actions related to insider trading and to hedge funds. Indeed, insider trading cases typically constitute 8 to 12% of our filed cases in any given fiscal year. As to hedge funds and purported hedge funds, they are a growing focus of our efforts. Just to illustrate, in fiscal year 1999, we had one case involving a hedge fund. During the last 3 fiscal years, in each year, we have brought in excess of 20 cases, and since that time, since 1999, over 100. The cases against hedge funds fall into 2 general categories: abuses that are directed at the investors in the funds, and abuses that are directed more at the market, such as insider trading or market manipulation. To date, this fiscal year, which has just started, we have already brought 2 cases involving hedge funds. We very much appreciate your support of this important work. My written testimonies, both for today and from September, go into greater detail on some of the programmatic issues. But I think it's important, in light of your expressed concern about the investigation of Pequod, to address it here very briefly. As you indicated, a former SEC attorney has alleged that the investigation was impeded and he was terminated because he sought to take the testimony of a prominent individual. Speaking for the Division of Enforcement, these allegations are simply not true. After an unhappy probationary period of employment, The former employee was terminated on September 1st, 2005, because of his inability to work effectively with other staff and his unwillingness to operate within the Securities and Exchange Commission process. As discussed in the SEC's termination letter, which is attached to my testimony, he had continued personality conflicts with other staff, he resisted standard supervision, and he ignored the SEC's chain of command. Despite these problems, the SEC attempted to accommodate him. He was, at his request, transferred from his original supervisor to a supervisor he selected and about whom he now bitterly complains. He also requested and received official time to pursue an unsuccessful age discrimination claim against the SEC for failing to hire him on 22 prior occasions. The EEOC denied those claims in a thorough written opinion, which is also attached to my testimony. Regarding the substance of his work, among other things, he issued, without his supervisor's review or approval, subpoenas that violated federal privacy law, which were withdrawn after his supervisors learned of them. But for the supervisor's corrective actions, the former employee's work product could have been extremely damaging to the SEC, and his continued resistance to supervision created a substantial risk of future error. After the SEC had expended considerable effort to make the employment relationship work, we decided not to extend his employment beyond the one-year probationary period. Moving to the investigation of Pequod, the potential insider trading by Pequod, as well as other potential securities law violations, were thoroughly investigated. The investigation was conducted in large part by staff other than the former employee and was continued long after he left. Ultimately, we did not find sufficient evidence to support an enforcement action. Accordingly, our investigation was closed for lack of evidence. The closing memorandum summarizes the many hours of hard work by the SEC that did this investigation, and it too is attached to my testimony. Finally, and perhaps most importantly, Mr. Chairman, the three supervisors working on the Pequod investigation collectively have decades of experience and have brought some of our toughest cases. They are also, each of them, smart, dedicated, and honorable. Their decisions in Pequod were not influenced by who any potential witnesses were, but rather by the facts and the evidence. This is consistent with the finest traditions of our agency. We follow the facts, and if those facts take us to John or Jane Doe, or some more famous John or Jane, so be it. We have gathered evidence from and about, and in some instances we have sued, captains of industry, presidential cabinet members, members of Congress, and celebrities, as well as thousands of people who are less well known. Indeed, a long list of prominent and not so prominent individuals would undoubtedly testify that the Enforcement Division does not pull its punches. I want to assure you and the committee that we are passionate about our work and we will pursue it with vigor, skill, and fairness. And I, too, would be happy to take any questions.
Thank you very much, Ms. Thompson.
Thank you.
We turn now to Mr. Mark Kreitman, Assistant Director, Division of Enforcement of the SEC. Supervises a 15-lawyer investigative group and was one of Mr. McGrory's superiors during his time at the SEC. Previously, Mr. Kreitman served as Assistant Chief Litigation Counsel for the Division of Enforcement, and prior to joining the SEC was a partner at Shea & Gould. Holds an undergraduate degree from Yale and a law degree from Harvard. We appreciate your being with us, Mr. Kreitman, and look forward to your testimony.
Thank you very much, Thank you very much, Chairman Spector. I've also prepared written testimony, which I request be made a part of the record.
It will be made a part of the record.
Thank you for the opportunity to testify. The concern raised in this inquiry was the possibility that political influence may have distorted the Commission process. I can say categorically that no such thing affected the conduct of the Pequod investigation, Mr. Aguirre's termination, or the decision not to take testimony from John Mack while Mr. Aguirre worked at the Commission. The Pequod investigation was pursued with vigor and professionalism after Mr. Aguirre departed, when all reasonable leads were exhausted, the relevant individuals questioned and documents examined. It was recently closed with no action taken. As you've indicated, I've been an assistant director and before that an assistant chief litigation counsel, trial lawyer, with the Division of Enforcement for 19 years and have received a variety of awards and commendations. I've investigated or tried cases against a prominent, against a department head at a major New York law firm, the president of a Beverly Hills bank, the son of a prominent local banker, First Jersey principal Robert Brennan, and numerous Wall Street luminaries. I brought one of the cases, insider trading cases, against a major hedge fund within the past year and a half, and I recommended successfully the largest whistleblower award that the Commission has offered. In 26 years of public service, I've played a role in recovering nearly $1 billion for investors and for the government. Mr. Aguirre was a student of mine at Georgetown, where I teach as an adjunct and have since 1999. I advised him and supervised his master's thesis, which, as you indicated, was published in a number of journals. We became friends and socialized together, and that, Senator, has made this entire episode particularly painful for me and for my wife. When Mr. Aguirre graduated from Georgetown, he had not practiced law for a number of years. He had no experience in enforcement investigation. He was unfamiliar with a closely supervised working environment like the Commission, where investigative zeal must be tempered by respect for the rights and legitimate interests of citizens, and where collegiality and mutual respect is the hallmark. Mr. Aguirre was a hard worker, but unfortunately treated his colleagues who questioned him or his methods with disrespect bordering on contempt. He was unable to fairly and impartially balance evidence against his preconceived conclusions or articulate his thinking in a linear fashion. He viewed all supervision, direction, even inquiry concerning his work as unwarranted intrusion. Beginning in June 2005, he came to believe that John Mack tipped Pequod about the G.E. Heller acquisition. He heatedly insisted that we subpoena Mr. Mack before he had evidence that Mr. Mack had access to inside information or indeed any potentially inculpatory evidence with which to confront Mr. Mack. His supervisors, with, as Ms. Thompson has indicated, more than 40 years combined Commission experience, instructed him of the need for proper foundation to invoke compulsory process, and that premature testimony would likely be fruitless because Mr. Mack could simply deny any illegal activity or any connection to the suspicious trading. Mr. Aguirre concluded that this proved a widespread conspiracy to thwart him and protect an individual no more significant or powerful than people from whom we take testimony every day, including during this same time period, a former United States Senator and a former high-ranking White House official. Toward the end, Mr. Aguirre's behavior became increasingly unprofessional, irresponsible, and erratic. He threw what can only be fairly described as tantrums, storming down the halls in a furious crouch, abruptly leaving the office without leave, resigning at least twice, necessitating that, despite severely limited resources, we were required to double-staff his investigation. Finally, as Mr. Hansen mentioned, he announced that he refused to write up his investigation in the required formal memorandum. Mr. Aguirre did receive a two-step increase effective shortly before his termination. That was for the rating period that ended 4 months earlier on April 30. He was a new employee. He worked a great many hours. I wanted to encourage and help him readjust after a troubled beginning in another group. His subsequent behavior, however, so far exceeded the bounds of acceptable professional conduct that it was incumbent upon me and his other supervisors to supplement and correct that overly generous evaluation, which we did on August 1, a month before Mr. Aguirre's termination. I'd be happy to answer any questions, Senator.
Thank you, Mr. Kreitman. Mr. Kreitman, in your written testimony, you state that Mr. Aguirre's theory regarding John Mack as a potential tipper was a, quote, highly suspect and illogical conclusion. And yet I note on a written communication on June 3rd, 2005, email to Aguirre that, quote, Mack is another bad guy in my view. Was that your memorandum, or was that a memorandum from Mr. Hansen?
I don't believe those were my words, Senator.
Not your words.
I don't believe so.
Were those your words, Mr. Hansen?
I believe they were.
And why did you say that Mr. Mack was another bad guy?
I can't remember why I said that at that time. In hindsight, I was trying to encourage probably the investigation to wherever it led. And looking back, in hindsight, those words were probably inappropriate. I've subsequently met Mr. Mack.
You don't remember?
I'm sorry?
You do not remember?
Do not remember.
Mm-hmm. Well, it was your written testimony that Mr. Aguirre's theory regarding John Mack as a potential tipper was a, quote, highly suspect and illogical conclusion, close quote. Do you still stand by that?
I do.
Mm-hmm. But you can't explain why in a memo contemporaneously with these events back on June 3rd that you said Mack is another bad guy, parenthesis, in my view, close parenthesis?
I can't remember why I sent the first email. That's correct.
Mm-hmm. Well, was Mack another bad guy in your view?
At the time that I wrote that, I can't remember the basis for which I wrote it, but I certainly do not believe Mr. Mack is a bad guy.
It didn't come out of thin air, did it, Mr. Hansen? Is this your statement at that time?
It was.
Your statement at that time?
That's correct.
Bad guy.
Correct.
But you don't know any reason you had to say that?
Excuse me?
You don't know any reason that you had to say that at that time?
The only thing I can think of sitting here today is that he had the reputation as Mack the Knife.
Well, tell me a little bit more about the reputation. What was his reputation as Mack the Knife?
I think he had the reputation of, again, his name was, or his nickname was Mack the Knife, because he had terminated a number of employees when he went to work at a couple of brokers.
Because Mr. Mack had terminated employees?
I believe that's correct.
Anything else?
No.
Well, terminating other employees, why would that lead you to call him a bad guy?
Again, Senator, I cannot remember why I read that email, and thinking back today, I just can't come up with anything other than that.
Okay. We now turn to Mr. Paul Berger, partner at Debevoise & Plimkin, joined the Securities and Exchange Commission in 1992 and served as Senior Counsel, Branch Chief, Assistant Director, and Associate Director. And in his latter capacity, he oversaw Mr. Kreitman's unit. Prior to joining the SEC, he practiced law with Jenner and Block and was a staff attorney to the D.C. Circuit Court of Appeals. undergraduate degree with honors from American University, and a law degree from the Antioch School of Law. We appreciate your being with us, Mr. Berger, and the floor is yours.
Thank you, Chairman Specter. Good morning. Thank you for the invitation to appear before this committee today and to respond to allegations of abuse of authority that have been made by a former staff lawyer with the United States Securities and Exchange Commission. I believe that accountability and oversight are healthy, and I commend you, Mr. Chairman, for taking these matters seriously. Indeed, I welcome the opportunity to respond to these allegations. For months now, allegations have circulated around town about this matter, but the SEC and I have been unable to respond to because of our obligation to refrain from discussing confidential SEC investigations. Finally, we have a chance to put these allegations to rest, for they are completely false. As background, let me give you a sense of who I am. I spent 14 years as a career law enforcement officer for the United States Securities and Exchange Commission, the last 6 of which as an Associate Director of Enforcement. As an Associate Director, I had anywhere from 150 to 200 open investigations under my indirect supervision, as well as supervising current litigation. I authorized the opening of the Pequot investigation before Gary Aguirre joined the Commission, because I believed then, as I do now, that hedge funds play an important role in our capital markets. And I, along with my colleagues, wanted to ensure that hedge funds conduct their affairs consistent with the laws prohibiting insider trading. When issues arose as to possible insider trading, I decided that despite the considerable age of this particular matter, we should take a hard look. As I'm sure you're aware, insider trading investigations are some of the most difficult cases to make. Establishing that someone had material non-public information and used that information to violate the anti-fraud provisions of the federal securities laws is exceedingly difficult. In fact, it's more difficult than making a financial fraud case. Nevertheless, we opened the Pequot matter to look into concerns about possible insider trading. Now, there have been various allegations about that investigation that need to be addressed. First, I have heard that the SEC's investigation was stopped. Nothing could be further from the truth. Not only did the investigation continue for a year after Gary left, but we added 2 terrific staff lawyers to the case because, in part, we had become concerned with Gary's reliability since he had resigned on a number of occasions. Next, and this is particularly key, the major issue that we confronted in the investigation was not if we would take Mr. Mack's testimony, but when we would take it. As I told Gary at least twice, the SEC is not and never has been afraid to take anyone's testimony. What we needed to do in the Pequot investigation was to get our ducks in a row. We needed to do our homework before we took Mr. Mack's testimony. The SEC supervisors made a judgment based on years of experience conducting SEC investigations, and particularly insider trading investigations, that the, that the best time to take the testimony was at the conclusion of the investigation, when all the evidence had been assembled, all of the leads had been run down, and when the U.S. attorney, who I had contacted in the first instance about this matter, had reviewed the evidence and completed their investigation. It was our professional judgment that the best and most efficient use of our resources was to conduct the investigation in this manner. Now, there are those who might say, well, what's the harm in taking the testimony when Gary wanted? Well, that would be an interesting standard for determining when to take testimony, as long as we do no harm, but that's not the standard. No, experience shows that the most efficient and productive way to conduct an investigation is to take testimony when you have marshaled all of the facts necessary to take the witness. As I'm sure you're aware, as a former prosecutor, taking the testimony of witnesses multiple times creates a murky and sometimes unusable record. There's also been the suggestion that Mr. Mack was given special treatment when, in 2005, lawyers, not for Mr. Mack, but from Morgan Stanley's board of directors, called to see if Mr. Mack had regulatory exposure. Both my assistant director and I told counsel that it was premature to draw any conclusions about the investigation. That was the right call. Why? Because it was consistent with SEC policy not to disclose confidential information about the investigation. I told counsel that we couldn't say whether Mr. Mack had any exposure or not, that we couldn't help Morgan Stanley with its decision. It would have been inappropriate for SEC staff to insert itself in a regulated entity's business decision. That was true since at the time, as Gary admits, we didn't know whether Mr. Mack had violated the law. This investigation was conducted like every other investigation. Experienced supervisors made sure that we were balancing all the facts in the evidentiary record and making the correct professional judgments. One can disagree with those professional judgments, that's fine, but it is beyond the pale when when one turns those judgments into a conspiracy that ropes in SEC supervisors and the commissioners themselves. I was a public servant who worked for 14 years on behalf of our nation's investors in our capital markets. I tried to bring a passion for my work each and every day. Not a day passed that I didn't ask whether a judgment that we made was the right thing to do. I believed then, and I believe now, that our judgments were sound and our investigations were exemplary. Thank you. I'd be happy to answer any questions and ask that my prior testimony that was submitted be made part of the record.
Thank you. Thank you very much, Mr. Berger. We now turn to Mr. Eric Ribelin, joined the SEC in 1988, currently branch chief in the Division of Enforcement's Office of Market Surveillance. Previously served as a market surveillance specialist and senior market surveillance specialist. Numerous honors at the SEC, including a Chairman's Award for Supervisory Excellence in 2002 and an Enforcement Division Director's Award in 2000. Bachelor's and master's degree in economics from Eastern Illinois University. Thank you very much for your contribution here, Mr. Ribelin, and we look forward to your testimony.
Thank you, Mr. Chairman. I don't have any opening statements.
Mr. Ribelin, there is a document which you sent to Mr. Hansen, a memorandum or communication from you to Mr. Hansen dated September 9, 2005. Ray Pequod saying this, quote, Bob, I have serious misgivings about many decisions made in this investigation. I don't know what all has driven the decisions. Something smells rotten, though. I'm accusing you of nothing. You seem like a good guy, but you're certainly a good soldier. But I'm nonplussed by issues big and small about the course of events going back to January. I really do need to contemplate my involvement going forward, close quote. Mr. Ribelin, what did you mean by, quote, something smells rotten, close quote?
Mr. Chairman, we had an aggressive investigation into possible insider trading by Pequod and possible stock manipulation. Gary Aguirre is a tenacious investigator. He had an aggressive investigation. In my judgment, he was professional. We had very worthy adversary, the best lawyers, the smartest lawyers who could be hired to defend, and they were extremely aggressive, and let me give a couple of examples. In a subpoena requesting the production of email, we frequently didn't get production of those emails in a timely fashion. We took testimony of witnesses and had documents that had been subpoenaed to be associated with testimony of those witnesses, and documents would show up in the 11th hour prior to testimony or on the day of testimony. And it's extraordinarily difficult to conduct a testimonial session when we don't have documents. Repeatedly, Mr. Aguirre attempted to hold the feet to the fire of the attorneys on the other side to get email production pursuant to subpoena, to get documents produced on time so that we could take testimony and do it appropriately. He continued to aggressively try to enforce the subpoena, if you will, and continued to go to his supervisors to get assistance from them that these subpoenas get enforced internally. And there was certainly a period of time when Mr. Kreitman and Mr. Hansen seemed to agree with Gary. But I can tell you that I was surprised from January of 2005 that Paul Berger who had a reputation for being an aggressive and smart attorney, did not seem as though he was aggressive in supporting the attempts of Mr. Aguirre to get subpoenaed documents on time and to get email production so that we can conduct an investigation. That's one example of what I was referring to when I said something smells rotten. That went through a very long period of time of the investigation where it was my sense that there was not the support for the aggressiveness and the tenacity of the investigator. There are other examples I can give you.
Would you please do that?
I can do that. There, as I said, for a very long period of time, we had a hard time getting email production. And I can tell you that if you subpoena a document or subpoena emails and you don't get them, you're not going to be able to do the investigation. And so we continued to push. There was a period of time when a very significant, large portion of emails were put out of our ability to get a hold of and to examine. Part of the reason given was because these emails may be privileged emails, communications between attorney and client. We thought certainly there was a possibility that some of those emails fell into that category, but there was a very large number of emails that we suspected fell outside of that category. And there was one point that an attorney was hired who had custody of some of those emails. I can't remember how many thousands they were. Mr. Aguirre was not allowed by Mr. Kreitman to speak to that attorney about trying to get production of emails. To this day, I don't know why that is. And I can tell you that Mr. Mack had been the CEO of Morgan Stanley. He was being courted to become the CEO of CS First Boston. We did not have information that he had material non-public information as it related to the GE Heller merger. That's for sure. It was Gary's theory. I agreed. I think other people supported the idea that it wasn't unlikely. It was certainly possible that he could have gotten access to the information based on the fact he had been a former CEO of Morgan Stanley, and he was being courted at the time by CS First Boston of the trades engaged in by Pequot. After the word came down that the testimony of John Mack was not going to be taken, I had a conversation within a week or so of that with Bob Hansen. And Bob Hansen said to me that because Mr. Mack was a prominent person or because he had connections, I don't remember exactly how I put it, that we would have to be careful about taking his testimony. We'd have to, my impression is, move maybe more carefully than we would if it was somebody other than somebody of prominence. And I said, well, Bob, if that's the case, why not just call him up on the phone instead of bringing him in for testimony and ask a couple of basic questions. And this is something, by the way, that Gary Aguirre proposed a couple of times. Mr. Hansen didn't respond to me. And then finally, of course, Gary Aguirre was fired when he was on vacation. And I was stunned. I was outraged. And the email that you just referred to was soon after these events.
Mr. Hansen, do you recall the comment that Mr. Ribelin has testified to, that you called Mr. Mack a prominent person and then suggested that there would have to be treatment of him a little different?
I certainly felt he was a prominent person, and I wanted to, as I've said to Mr. Aguirre and Mr. Ribelin, I wanted to make sure we had our ducks in a row before taking Mr. Mack's testimony. And what I meant by that was, let's figure out what we can about whether he had the information before taking his testimony.
Well, what would you be looking for as to what information that that he would have had?
Whether he had the information regarding the deal, whether he had the inside information.
Well,
I mean, there's
wasn't it-
hundreds of suspects or possible witnesses we could take the testimony from, almost an endless number of them. One of the things you want to try to look at as a criterion is whether or not they have access to the information. These merger and acquisition deals are highly sensitive matters within investment banking firms, and they don't give that information out willy-nilly.
Well, it's not a matter of who else has access. It's a question of whether Mr. Mack would have access. And isn't it true that in his position with Credit Suisse, that he did have information about the prospective merger between GE and Heller in the July 2001 timeframe?
After he joined Credit Suisse First Boston, it's certainly entirely likely that he would have had that information.
Well, so
But prior to that time, no. And that's the trading period that we were looking at prior to that time.
how about that, Mr. McGrory? What time period was in question?
Time frame in question was from July 2nd through July 25th. There were 3 dramatic trade moves by Mr. Sandberg during that time. July 2nd, he opened the trading. July 9th to 10th, he went from 15,000 shares to 450,000 shares in terms of what he was trying to buy. And then on September 25th, he shorted. Now, that fit perfectly with the timing of Mr. Mack. Mr. Mack, according to Mr. Padalino, who was CSFB's attorney, told me that he had met, that Mr. Mack had met with the CSFB people on approximately June 28th or June 29th. I knew that
So Mr. Mack had met with people who had the insider information prior to the July timeframe you testified about?
well, he met with CSFB. I was told he met with CSFB people at that time on June 28th. And now, that's coming from the lawyer on the other side. Of course, I would want to verify that and talk to Mr. Mack. Who exactly did you meet with?
But that would have required questioning Mr. Mack.
That would require it.
But there was that contact in late June, June 28th, as you testify.
That was the first one.
Let me finish the question, where Mr. Mack would have had access to the inside information.
Potential access to that information.
Well, how about it, Mr. Hansen? Wouldn't that establish a necessary predicate for questioning Mr. Mack?
Mr. Aguirre believed that Mr. Mack may have gotten the information from, I think one of his hypotheses was that he may have gotten it as part of a courting process with CS First Boston. That seemed highly unlikely that CS First Boston, in courting Mr. Mack, would tell him confidential, non-public information about a deal in their courting process. Not only that, but Mr. Aguirre was told by CS First Boston counsel, and this is the part that he excludes from his testimony to the Senate, that the person that Mr. Mack met with didn't have the information.
Well, what other information did you have about Mr. Mack's potential involvement when you finally did take his deposition, 5 days after the statute of limitation expired?
When we finally took Mr. Mack's testimony, we had, subsequent to Mr. Gary's termination, we had actually gone to CS First Boston, subpoenaed their records to see whether or not the people that Mr. Mack had met with actually had the information. We first did that. Then
And did you find they did have the information?
we did not. Then we
Why did you wait so long to subpoena those records?
We subpoenaed them September 1st, the day that Mr. Geary was terminated. So there was no time delay at all.
Why was Mr. Mack's deposition taken so long after that?
I'm getting there. We subpoenaed CS First Boston records. We did an extensive email review of Mr. Mack's records, and we found additional exculpatory evidence that sort of suggested that the likelihood of Mr. Mack being the tipper was minuscule. We turned our attention and our focus to another transaction that Pequot was engaged in approximately November of 2005. We followed that through until approximately June 2005. At that point, we decided whether or not we were going to take additional individuals in connection, I'm sorry, 2006, additional individuals in connection with the GE Heller transaction. At that point in time, we took the testimony before the statute of limitation expired of the individuals at CS First Boston who potentially could have passed the information on to Mr. Mack.
Well, why not take Mr. Mack's deposition before the statute of limitations expired?
We took the testimony of the two individuals who could have given Mr. Mack the tip or the information before the statute of limitations expired. If we found out from them that Mr. Mack had gotten the information or that they had the potential of giving the information to Mack, we probably would have sought a tolling agreement. We sought tolling agreements from Pequot in March of 2005.
Well, that's all very interesting about tolling agreements from somebody else, but you didn't seek a tolling agreement from Mr. Mack.
I don't think we could have. We didn't have the evidence that he had the information.
Well, okay, if the tolling agreement is out, and I wonder why you mentioned it, if it wasn't relevant as to Mr. Mack, why